All right, future barristers, let's talk UCPR for the Queensland bar exam. You already know these rules are a big deal, right? Well, today we're zeroing in on a really tactical part of the playbook, appointing experts before you even file a claim. Honestly, getting this right can be a total game changer. And for the exam, you've just got to know this stuff cold.
Okay, so here's what we're going to cover. We'll look at the whole battle of experts problem, then jump into the UCPR's fix. We'll break down the two main ways to appoint an expert, by agreement or by court order, and then we'll get into what happens after they're on board. Let's get to it. So first things first, why do these rules even exist? Well, they weren't just invented for fun. They're a direct answer to a massive, costly headache that pops up in litigation all the time.
And this quote from the UCPR commentary just nails it. It perfectly describes that classic situation, right? By the time you get to court, both sides have already found their own expert, their own hired gun, to back their case. And what does that lead to? A battle of the experts. It becomes less about finding the actual truth and more about who can poke more holes in the other side's report. It's expensive, it's messy, and it makes settling a case way, way harder.
Okay, so that's the problem. What's the solution? Well, you'll find it in Chapter 11, Part 5, Division 4 of the UCPR. Think of this whole division as a special toolkit designed to stop that battle before it even begins.
Now, here's the first big exam tip. Pay attention to this one. Rule 429Q. This rule tells you that these specific pre-proceeding expert rules, they apply only to the Supreme Court. Got it? When you see Division 4, think Supreme Court. It's a critical limitation you have to remember.
So the whole game plan here is pretty radical, actually. Instead of two competing experts later on, the strategy is to get one single independent expert on the job before anyone even files a lawsuit. It's about getting a neutral opinion early on, which can often be the dose of reality both sides need to just sort things out and avoid court altogether.
All right, so how do you actually do this?
Well, there are two main paths. Let's start with the friendly one, the cooperative path. This is covered by Rule 429R, and it's all about appointing an expert by agreement. Okay, so under Rule 429R, subsection 1, it's not enough to just have a chat. You have to agree, in writing, on these 4 specific things. It's like a checklist, and you have to tick every box. 1, a dispute exists. 2, who the expert is. 3, the timeline for the report. And 4, who's footing the bill. If you miss even one of these, your appointment under Rule 429R is invalid. Simple as that. Now this is the kicker. Rule 429R, subsection 6. If you're studying for the exam, circle this, highlight it, do whatever you need to do. Because this rule says that unless a court gives you permission later, the expert you both agree on is the only expert who gets to give evidence on that issue. You heard that right. The only one. The stakes are huge. You're basically locking in your expert evidence right at the very beginning.
But, let's be real. Parties don't always want to cooperate. So what happens then? What if you can't agree? Well, that's where the second path comes in, Rule 429S. This is when you go to the court and ask it to appoint an expert. So if you're the one filing the application under Rule 429S, you've got some homework to do. Your application needs to spell out what the dispute is, why you need this report now, and, this is a big one, you have to name at least 3 qualified experts who've already agreed they're willing to do the job. And you gotta be transparent too. Disclose any connection you have with them. The whole point is to give the court a real choice. So, let's put these two side by side. It's pretty straightforward, really. Rule 429R is the let's work together route. Joint agreement, you pick one expert and you decide on costs together. Rule 429S is the we can't agree route. One party applies to the court, you have to propose at least 3 experts, and guess what? The person applying usually has to pay for it, at least at first. Cooperation versus court intervention. Okay, so you've got your expert, one way or another. But the story doesn't end there, not by a long shot. Now we need to talk about the duties that kick in after they're appointed. First up, there's a really important rule protecting the expert themselves. It's Rule 429J. And it basically says an expert has the same immunity for what they write in their report as they would if they were testifying in court. Why does that matter? Well, it's so they can give their honest, unvarnished opinion without worrying about getting sued for it. It's all about ensuring independence. Okay, now for a scenario that you will definitely see on an exam, and you'll probably see in real life too. Imagine this. Your expert gives you their report, but then something changes.
Maybe new facts come out. Maybe they just rethink it, and they change their mind on something important. What happens next? What do they have to do? What do you have to do?
The answer is in Rule 429K, and you have got to know this process inside and out. It is a mandatory 4-step dance. Step 1, the expert has to tell you they've changed their mind on something material. Step 2, they have to put it in writing ASAP explaining the change. Step 3, that notice comes to you. And now, for your part, Step 4. As the party who got the notice, you must, and I mean must, go to the court and ask for directions. It is not a suggestion. It is a duty under Rule 429K. All right, last major piece of the puzzle, disclosure. You've got the report. Great. Now what? You can't just keep it to yourself. Rule 429I lays down some very strict deadlines you need to follow. So here they are, straight from Rule 429I. Bar exam students, you need to memorize these. The plaintiff gets 90 days after the close of pleadings to disclose the report. The defendant gets a bit longer, 120 days, which makes sense, right? It gives them time to react to the plaintiff's case. Everyone else gets 90 days. And these aren't suggestions, they're hard and fast deadlines, unless the court says something different.
So let's pull this all together. What are the big takeaways? First, this whole part of the UCPR is designed to stop that battle of experts and push for an early resolution. You've got 2 doors to get there, Rule 429R by agreement or Rule 429S by court application. But no matter which door you go through, you're probably ending up with a single expert. And don't forget those crucial follow-up duties, Rule 429K for a change of opinion and Rule 429I for your disclosure deadlines. Got it?
Okay, I'll leave you with one final thought, something to chew on as you move from student to practitioner. We've talked about how great these rules are for early resolution, but when could using them be a massive tactical blunder? Think about it. When might it be a terrible idea to lock yourself into one expert's opinion before you've even seen all the documents, before discovery, before you really know the full shape of your case? Knowing when to use these rules is smart, but knowing when not to, well, that's what makes a great barrister. Good luck with the exam.